So good morning. Hello, everyone. How are you? If you could take a seat and maybe close the doors at the back, we're going to get rolling. This is an hour-long session. I'm Tim Murphy. I'm an executive partner at McMillan Law Firm and practicing in the P3 space for quite a long time. And I'd like to proceed to introduce the panel, and then we'll get right to it. So first is Agnes Hagen from Infrastructure Ontario, who's a VP Legal there, has been a lead legal advisor on a huge number of their largest deals, has her Bachelor of Laws from BC, and is a runner. And then next is Jason Annibale, who is a litigator and national co-chair of the construction law group at McMillan. He has acted for authorities, developers, and contractors in P3 disputes, and is a soccer coach. Really leaves running to other people. Next is Hagit Elul, who is a partner and co-chair of the arbitration practice at Hughes, Hubbard, and Reed, is recognized in arbitration by the Legal 500, is called in both California and New York, so therefore is laid back and tough as hell at the same time. She is both a litigator, but has also acted as an arbitrator in a number of proceedings, especially in international commercial disputes. And then last but not least, Patrick Freer, Senior Vice President Asset Management at Fengate. He is the scariest guy up here because he's both an engineer and an MBA, and has led Fengate through a number of important projects and the occasional dispute. So I should say that we have a process where you can go on to the CCPPP app and write in your questions, and they'll scroll on a screen for us, and we'll pick the ones we like. So John McKendrick, you don't need to bother. But in any event, so I want to get it to the panel. We're going to talk through some of the issues, obviously, in dispute resolution, particularly in the P3 context, for good, bad, and occasionally success. But maybe I'll start, Agnes, with you, and talk a little bit about sort of what IO is seeing in terms of disputes with, obviously, between authority and project companies, how you see those working, and what IO is doing as it gets more experience.
Yeah, of course. So, I mean, at Infrastructure Ontario, it's been an evolution. We've now closed over 100 projects, so we have a lot of experience closing projects. We have a lot of experience in the transactional phase. We've started to focus a lot more on the construction issues and the disputes that arise during construction and also during operations. So part of that is a constant feedback loop. So we have continuous improvement groups where we try, when we have issues that arise, because we have a steady pipeline of projects, we try to address those issues then in the next project. So we resolve them on the projects where they're occurring, and then we try to address them in the future projects. The latest, so we have many contractual mechanisms that we've introduced to try to minimize disputes. So, I mean, our number one objective is reduce the disputes, because that doesn't lead to a good relationship. Claims are one matter, because you will always have a risk allocation and certain claims, and there's a certain amount that each party takes on as a risk, and those claims should be considered differently from when you get to a dispute. So we've developed those mechanisms, and the latest, we did a few years introduce a claims committee to address claims, and that's from the perspective of we have a senior group from our project managers, from our delivery team, from our finance team, from our legal team, and the team that has an issue or a claim brings that issue forward, and it's an opportunity for others at IO to question, to challenge that resolution of the claim, to make sure that a more of an independent view has been given to that issue that's more impartial. And we will also hire cost consultants sometimes to consider the claim. And the final step in this evolution has been that we now have a dedicated dispute resolution management team. And that's in recognition of the fact that we are now a mature organization. We do have a number of disputes, and we have to become more systematic, more strategic, and consider those disputes across the program and not just on an individual project, on a case-by-case basis.
So maybe I can open this up for everyone, because one of the I mean, obviously, we are working in a sector where it's called a public-private partnership, with partnership being a key component of it. And then one of the issues then is how do you, thinking about that 25 or 30-year history, especially in the full DBFM, is how do you behave as if you're a partner while at the same time, looking to your contract and not giving away rights you might have by virtue of being a good partner. So maybe I'll start with you, Patrick, but have everyone speak to how you balance.
Yeah, I think that, from my perspective, that's the toughest balance we deal with on a day-to-day perspective. And for us, it's getting harder and harder as our portfolio's grown, because what typically would have been a project risk is now becoming a portfolio risk. And, we always feel a balance and, a fiduciary duty to our investors to protect what is their investment and their rights, but recognizing that and in time strict adherence to contract and putting forward positions that seem confrontational almost create a self-fulfilling prophecy of creating disputes. And that doesn't benefit either of the parties, and ultimately that becomes a very hard relationship to manage year over year for what is going to be, a 30-year period for the majority of our investments.
Anyone want to add to that?
Yeah, I'll take that up a little bit. I think that the structure that's provided within dispute resolution procedures in P3 agreements, they recognize and facilitate ongoing dialogue that encourages and understands that you have an ongoing relationship. So structurally, typically if there's a dispute that arises, either the independent certifier deals with it or it brings levels of management together to try and deal with it at the forefront. And then there are a number of other options that the parties can choose. So, for example, you may have an adjudication procedure that's provided or expert determination. A number of different mechanisms, short, certainly of full-blown litigation or arbitration, that allows the parties to dialogue, to communicate with each other, and protect that lengthier relationship. That being said, whatever structure you have, sometimes there are motivations in play. Indeed, I've seen them in my practice where you can have the best structure in place. There is sometimes a touch of animosity. So, for example, one way to not respect a 30-year relationship would be to raise allegations of bad faith, which have become somewhat fashionable since the dawn of Basin. While that's typical in hardcore litigation, forwarding that even within the context of an arbitration or shorter can sour a relationship pretty quick.
And if I can just add to that, I fully agree with what Jason was saying about the steps up to the full-blown dispute resolution process, be it arbitration or litigation. I come from the arbitration perspective, and I always find that seems better suited for maintaining the long-term relationship between the parties, because you're dealing with a private dispute resolution proceeding that isn't going to be aired in a public court, subject to whatever disclosure obligations that the parties have. But also that you can have an arbitrator that can really give the case attention and really direct it in a firm hand to not encourage disputes. And there's absolutely a role for a firm arbitrator to make sure that proceedings don't get out of control and that the parties aren't over-arguing positions, simply to preserve their rights.
So we have a question from someone in the audience, but I'm going to broaden it slightly, which is, one of the challenges, obviously, when we have a sector where everything's driven into private dispute resolution and discourage public litigation. The question fundamentally is how do others learn what the resolution of an issue is in a way that's helpful for them understanding. So you spoke to a portfolio of assets, so you can look across your assets, but how does that get transferred to someone else? So maybe I'll start with you, Agnes, in terms of how does the market understand, for example, how IOC has come to interpret it, but how does that work, and what have you found in terms of being able to learn lessons more broadly?
Yeah, it is an issue. For one, we always have to be mindful of confidentiality. So the advantage to having IO involved on projects across Ontario. And, it's not only where IO is the signatory to the contract. We also work with hospitals. We work with our co-sponsors, Metrolinx. We work with certain municipalities. But the advantage that if we're involved across the board is that we do learn from those other projects. And we as a team at least understand then what has happened and are able to apply that knowledge to the next project. We have to be careful about how we disseminate that because obviously there are often confidentiality issues. But that is one way that we address it. And the other one is really then to go back to the original contract and to amend provisions as required to reflect that new understanding of how something is interpreted. Or it can be, taking that approach and on other projects suggesting amending agreements, saying we've had an issue with this provision and the interpretation of it, and we suggest that we address it through an amending agreement so that the dispute is resolved that way on that project. So there are ways of working between or interact between the projects, but there is a careful balance we have to keep there.
Yeah, go ahead.
Well, I think from our perspective too, we use networking, like functions like this. We talk to other parties. We understand common issues that are arising so that they can be best resolved in the most efficient manner. Like you need to take these opportunities to have these discussions and talk these issues through as a group, as an industry. That'll ultimately lead to reducing the friction that can start to create as these things bubble.
And from the adjudicator's perspective, I think that there is actually a limited value in exporting decisions that are made, for example, in one arbitration proceeding into another proceeding. The facts always vary so much, and there's really a question of whether one private arbitral tribunal really can be granted sort of a stare decisis effect as to an issue by another private dispute resolution board. So, I have had cases where someone comes in and says, well, we had this exact dispute and it was decided this way. And I always find that of questionable value because, you don't really know who the arbitrators are. You don't know how they think about something and whether really the way that they viewed it, even if the facts are quite similar, whether that's really the appropriate analysis.
I'm going to pick up on what you say because I actually sort of curious about this because there's I don't know if anyone's read it, but there's a great article called Inside the Black Box, which is in the Journal of Construction Law, I think, in which they went out and interviewed hundreds of people in the construction industry and arbitrators and asked them a bunch of questions about how arbitrators view their process, how the industry views it. And actually one of the really interesting results of it was they asked a bunch of arbitrators how many times they strictly enforced the contract, and it was a surprisingly small number. So I'm wondering, in your experience both as litigators, business people, arbitrators, why is it that arbitrators are saying, I'm not always strictly enforcing the contract? What is driving that?
Well, I think it's sorry.
No, please go ahead.
I mean, I would say that it's questions of equity and fairness are really driving it. I mean, the facts drive any dispute, and if the facts are leading to one direction, then the arbitrator may take a view that, okay, well, I'm going to, not apply this technical provision of the contract that may lead to an outcome that's inequitable and unfair. And I don't necessarily think that's the wrong result. Courts act exactly the same way.
Yeah.
And, I think that that's inevitable, and I think it's appropriate because really when you look at a contract as a whole, you're not necessarily only supposed to be applying the technical provisions of a contract, but also reading into it what the intent and expectations of the parties were.
Yeah, that's well put. I do agree with Hagit. My experience generally has been that arbitrators are trying to do the right thing as are judges, and oftentimes they're trying to do the most expedient thing. So on a spectrum, if you're asking the arbitrator or judge to do something that's more difficult, and even though it's the right thing, it becomes a more difficult task to do. So you want to try and structure your arguments to lead the decision maker to understand that
the case you're advocating is one that makes good moral sense, it makes legal sense, it's the right thing to do, and it's a straightforward analysis. In that, my experience has been that the decision makers do try to breathe life into the contract most often. Certainly where there are principles of equity in play, what Hagit has said is exactly right, but oftentimes we're trying to make sense of a large, complex contract where all the provisions need to be read together. If you read one provision in isolation, you may come to one result, but reading it within the context of the full contract, you may come to another. So I guess
it's only 1,000 pages in our document.
It's only 1,000 pages. So I guess I'm resisting the premise of the question a little bit in that, you know, I do think that certainly my experience, decision makers try to make sense of the contract in front of them.
So Patrick, sort of picking up on that, so if as this I think probably makes sense, that facts in the end of the day drive it. So from a perspective of a developer, you know, as you see something developing in your project, and you're thinking, like, when do you have to start thinking about this could go to a dispute and I need to start worrying about, you know, whether I'm creating bad or good facts for that eventual adjudication down the road?
I think it's very important to understand the external forces that are at play at the moments when these items are occurring and really decide on a probability that this will end up in dispute. Because I think what was eye-opening, and I've now been through a couple large, multi-claim, very long, intensive discovery arbitrations that were a bit eye-opening on what was confidential, what was not, what was contemporaneous records. Sorry, I butchered it. I knew I would. Like what was important to arbitrators, and ultimately that in hindsight they were looking for the motivations and the behavior of the parties, and the behavior, whether it was consistent or inconsistent, really seemed to lead into their thinking. And from my perspective, most certainly, getting counsel's advice early when you feel that it is inevitable is very helpful in creating what ultimately ends up being a clean record and something that's a lot easier to decipher by the panel.
Yeah.
So, okay. And so, so how do you, like, so we've got that kind of tiered process in the IO documents now. Obviously, there's two different sort of kinds of disputes in these agreements. There's down the chain and then obviously up to the authority. And is that approach different for one versus the other, or?
From my perspective, it's not. And, you know, we're in a unique perspective that we are pure equity investors. So we rely on the authorities, the procurement agencies, as much as we rely on our contractors and our service providers or our owner operators. To me, I take it quite seriously on both directions of which way we would potentially go, and I don't think it would influence. It's pretty serious.
So do you find, so they've got, I was thinking about the tiered process, you know, you got management involvement and expert, and so do you find the management resolution step useful, or is it just primarily as an early warning signal for you?
So we've had success with it, but I think it really deals with the quantum of the size of the claim. And ultimately, what either party feels they're entitled to will lead to whether or not that is successful. Sometimes pulling a dispute out of the people that are in the weeds is very helpful, and it's very easy for management to see, like, I don't know why our colleagues are fighting over this. This is quite easy. It's a 50-50. Let's walk away. But I found more and more, the more sophisticated the industry's gotten, I've seen less usefulness out of the process over the years, and we found it's more just a step we follow before we send the first letter, and, you know, informing of a dispute process.
So I see we've got a couple more questions, but I'm going to ask the second one here, which is because it kind of fits with the next step from management, but it's the notion of the role of mediation in disputes, facilitated negotiation rather than arbitration or litigation, and how useful you found that, and to what degree that has been led to better results.
I'm a big proponent of mediation myself. I think that mediation, where you have a schedule in place leading towards an arbitration or a court date, focuses the attention of the parties. Mediation is one of those processes where parties maintain control together over the result of what they're going to get. And if you have two parties legitimately working together, assessing their risk, and hoping to avoid the larger costs of arbitration or litigation, it's a step that almost always makes sense. That being said, there are occasions where parties are entrenched, they're invested in their positions, and good counsel needs to make an assessment that a mediation will be a waste of our time in this circumstance. Thankfully, most of the time it isn't, but I've certainly seen occasions where parties are entrenched and mediating would not assist.
So Agnes, does IO have a view on this?
Yeah, I mean, we've considered it, and I don't mind on our side, we haven't used it before. It is, ideally, it's a great mechanism because you preserve the relationship, you have an outcome that everyone is supposed to live with, but you have to be sure that the parties will actually accept the outcome. So it could be a waste of time if the relationship is at that point where the parties they need a resolution and they need it to be binding, then the mediation process can just prolong that. So I think it really does. It is ideal if you're in these long-term relationships, but we haven't seen it yet be successful or yet play out that way. It isn't directly addressed in our documents either, so we often raise it as an option, but the tendency tends to be more adjudication.
I mean, I find mediation very helpful in these kinds of disputes, particularly where you're dealing with a long-term contract and an industry with a smaller amount of players. There's very good reasons to not go directly to a process that's going to build animosity. I hear the comment that it could be a waste of time. I do view the mediation process to be discrete enough of an investment of time that I think it's worth the risk of possibly wasting time by investing in, what could be just, a few days of a mediation process. And, some of the values of the mediation, for example, will be you have someone who's independent who can really sort of give you a perspective on your position and let you know, well, yeah, you think you have a very strong position, but have you thought about X, Y, and Z? And, that's invaluable. The times when I see mediation not working is when the parties have some sort of institutional reason that they cannot pull the trigger on a settlement. And they really, particularly when you're dealing with public entities, that they just may need a decision from an adjudicator that's telling them that they have to make this payment because they can't go to their constituents and say, well, yeah, we voluntarily paid out this amount of money. And you see that quite often in these P3 type of disputes. So that's one situation where, I think it doesn't work well.
The timing, I think, is also of crucial importance. If you're affecting a mediation too early in the process where the parties perhaps have not developed their positions enough, they may be unwilling to compromise them yet. And then, of course, conversely, if it's too late, where they've invested too much in the fight, they may be unwilling to resolve at a mediation too.
So let's assume we haven't been successful at a mediation. So when we get to the arbitration phase, is there a preference on 1 versus 3 arbitrators? Do people think one works better than the other, or does it sort of depend?
I mean, I think it depends on the quantum, but anytime you're dealing with some sort of infrastructure dispute, there's going to be a lot of money at issue. So I don't know why you would really want to trust that to one person that doesn't have anyone else to talk to or to sort of vet their opinions in. I think 3 is a much better resolution, particularly because you don't have a robust appeal process.
And so you've been an arbitrator, and do you find it useful having other people to be part of your panel when you're playing that role?
Yeah, absolutely. I mean, the job of a sole arbitrator is a very lonely one. You really have to you can't really talk to anyone else about it because the matter is confidential, and so you really have to puzzle through it yourself. And of course, it's always a little bit more reassuring when you have someone else to bounce ideas off of or work through troubling situations with.
And so if the 3, usually you get one side picks one and then they pick a third between the 2 of them. is like, do you find you're actually getting independent people, like, or are they representative? And how does that actually play out? Do the people one party picks feel like they're picking their champion, or you're trying to pick someone who's bringing some depth and consideration to the job?
Right. Well, you have to be careful about when you're a party or counsel hiring, selecting an arbitrator. You have to be careful about going for the hired gun approach, because that can really backfire. If someone's coming on too strong or seems too partisan, the other two arbitrators are going to shut them out. And, you'll even see that physically. You'll see that with arbitrators going to lunch and two of them are walking together and the partisan one's walking behind. And you can see that dynamic playing out. It doesn't work. And, that arbitrator who's taking too much of a partisan view really starts to lose credibility. So I think that that's a mistake approach. And, any arbitrator who is experienced enough will know that, okay, well, my role is to make sure that the positions of the party that appointed me are fully vetted, and I'm going to do that in a way that's nuanced enough that, I'm not immediately dismissed as sort of, this partisan hired gun.
And what about the notion of if you have a bunch of smaller disputes, you kind of have someone on call who can help you, and then it gets bigger, you move up to 3. Have you had practice with that kind of experience at all?
I mean, I certainly have, and right. I think that that's critical to having the dispute move along, having the project move along. I mean, typically I see it where that sole person is not the one that's then involved in the 3-party panel, so the dynamic is, easier that way.
I agree with much of what Hagit has said, and in particular, maybe a monetary threshold before you move to 3 arbitrators, because it is 3 times as expensive in terms of your disbursement for an arbitrator, for sure. But even as counsel sitting, the dialogue amongst the arbitrators is quite refreshing from counsel's perspective, and indeed the clients. That dialogue is worth something, particularly in disputes where the quantum is so high. However, where it's a bit more discreet, if you're not dealing with 15 to 20 supervening event claims, you've got a discrete item, using a single arbitrator or indeed an expert is expeditious and works quite well. I also wanted to take on the question a little bit about the hired gun approach. I have not seen that so much. I think typically parties want a fair hearing, and they hire not because they think someone's just going to see it entirely their way, but someone who has deep expertise in the subject matter that is the dispute. And so I've been in front of panels of 3, and we certainly know who we appointed, but I did not detect that either party was getting undue attention. I thought that the arbitrators were doing a good job in hearing the other side.
And is there any view as to whether those arbitrators should be subject matter, or do they all have to be lawyers, I guess is the real question.
I think it ultimately ends up in the dispute you're in. Like, when you get into multi-claim events, typically you are getting into the legal realm, and the costs, the implications, the liabilities all really do require that level of expertise, and hopefully with someone that has practiced very much in the construction industry or has grown up in it, like from our perspective being a construction dispute. From a purely technical matter of whether or not there was compliance, I think that usually can be resolved at some points through the referee process when you have an independent party come in, hear both sides, and ultimately take a decision on a technical matter. I think once you start talking to arbitration, at least our experience has been, it has a lot more to do with the legal ramifications of a contract and less to do with, say, compliance with specifications.
Yeah, I would agree with Patrick, because in the case of you have a dispute that arises and you end up going to arbitration, usually at that point, and at least under our model, we've gone through the independent certifier process. So if it's a technical issue, you've typically had that technical determination. By the time you get to arbitration, it's usually a legal matter, and in our experience, typically, maybe we're biased here, like I'm biased, but the legal skills are important to have. You can always bring in that expert testimony, you can bring in that technical expertise to bear on the panel, but in terms of the decision at that point, you're probably past a purely technical issue and you're into legal issues as well.
So how do you find good arbitrators? What's the best way to find good arbitrators?
I think it's word of mouth. It's recommendations from people you trust and people you work with. Yeah. Anyone else have anything?
Yeah, I would think people in the industry, experienced counsel that you know is out there networking and so gets to know the arbitrators and know how they think and, you know, has at least some bit of superficial rapport with them so that they can provide you with meaningful recommendations.
Obviously, it's key to have someone impartial, so not someone who's necessarily represented one side or the other consistently, because that can obviously have a bearing then on legitimacy of how the parties view the decision at the end. Because you want that decision or determination to be viewed as legitimate by both parties. So that's very important too.
So we're in an arbitration, and so one of the things I wanted to get was, you know, one of the advantages in theory of an arbitration is there going to be less technical application of the rules. They're going to be able to, if facts and equity are important drivers, then you might be less about the form and more about the function. And so then if that's true, one of the things I want to do is like, how does that, for you as a developer, how does that make you start thinking about, you know, your record keeping and what you're doing as a company for the projects going forward that you may not even have a dispute, but as you start thinking about how you manage your portfolio, does that make you change how you think about it?
Well, I think if you've experienced, you know, a very large arbitration, I think it's a bit eye-opening on what becomes part of the record and how driven the panel is to understand the facts of the case. And, you know, when you get to that point and you realize what you have felt is confidential in your past and you suddenly realize is an open book when you really get to this point, I think you will document stuff moving forward in a different fashion. And I think more so, not with ill intent, I think my focus is now, as I'm writing my notes, making sure if I go to read them 3 years later, when we finally get to a point of hearing, do they make sense? Like, will this make sense with the elapsing of time of what I was actually trying to say when I wrote in my construction diary what was occurring at these moments in time? And I think you'll also put some of those notes together or records together of some of the factors that were at play at those moments so that you're not just relying on hearsay when you finally get into a hearing.
Yeah. Longer emails with less swearing in them?
I've learned that well before I had to get to an arbitration, so.
Yeah. And like what?
Yes, so the premise of the question is, of course, right. The rules of evidence are more flexible within an arbitration, and depending on what rules of arbitration you're using, the words will differ, but a couple of examples. Ontario's Arbitration Act references the Statutory Power and Procedures Act when it comes to evidence, which allows the arbitrator to consider any evidence that's relevant and not subject to privilege. In BC, the Arbitration Act identifies there that the arbitrator or arbitrators are to admit all evidence that would be admissible in court, but may also admit all relevant evidence subject to the rules of natural justice. So that creates some real flexibility. Issues of hearsay are less concerning, and certainly within a construction or P3 context, you're dealing with a robust paper record. That is one element. The more important element is having a document agreement with opposing counsel that makes some sense, so that the parties understand what's on the record. And more than the parties, the arbitrator understands what's on the record. Because in my experience, an arbitrator or a panel starts to get nervous when they're unsure of what documents are on the record and which ones they're going to have to make rulings on. And I've been in a circumstance where the process of incessant objections on particular documents becomes a disturbance to the hearing and troubling to the arbitrators. So if counsel get together at the front end and put together a document agreement so everybody knows which documents we're talking about. Tremendous benefit to the hearing process from your arbitrator.
So, Hagit, you've been an arbitrator. How do you, when you're looking at the reams of paper and documents, how do you think about it as an arbitrator?
Well, I mean, you're really relying on counsel to make a cogent presentation of the evidence, you know, the more counsel can agree on something, the easier it is. As an arbitrator, you very much encourage counsel, you know, as Jason was saying, to go ahead and make sure that they're agreeing on which documents are in the record. And I always consider it sort of how you deal with your children, that if, you know, I don't care whose fault it is, come to an agreement, otherwise I'm not going to listen to either of you. And, you know, I think that counsel would be well advised to sort of follow that rule, because, you know, arbitrators get very annoyed when time is spent on sort of meaningless disputes instead of just really focusing on making sure that the record's, you know, presented thoroughly to the arbitrator.
So we have another question from the audience here, and I rephrase it slightly, but that is, you know, it's an interesting question in the P3 context, and you referred to it a bit, Jason, as well, which is, you know, we've got huge, massive documents that are long and some very specific drafting, but the point of the whole document is actually, you know, to create an output specification that you're supposed to ultimately manage the risk towards. And I guess the one question is, how do you balance both when you're in, you know, an arbitrator or a participant in the process or a lawyer for it? How do you create an understanding of how a P3 is supposed to function, what it's supposed to do, and how that should inform how they look at whatever the particular dispute is? And how do you not just get this clause says X, but if you actually take it into the broader context, it might actually have a different layer to it if you're trying to get to the, you know, the facts and equity. And how do you make that easy to understand for an arbitrator?
Wow. Well, that's the magic of advocacy, right? Yeah. That's the magic of storytelling in some ways. And I'm quite serious as I say that. I mean, that's the job of each counsel, to tell a compelling story. And when I say story, I don't mean fiction. I mean telling a compelling story from the perspective of your client that makes sense, that identifies the project at issue, identifies its purpose, explains the purpose of the specifications, and proceeding from there. One tool that can be used, and I've never actually pulled the trigger on this, but taking a view of the asset is something that the panel may wish to do, or counsel might like their panel to do. Otherwise, the use of pictures within the arbitration room can also be effective. An arbitration room can be a pretty technologically advanced place, in my experience, where you have computer screens that are up, everybody's working from their laptops. That's often how it goes. So you are equipped to tell a compelling story, as I said. Agnes, did you want to give?
Yeah, I was just going to add on that, I mean, given how complex some of these decisions are, it ends up being very, you end up having to find the right mechanism to approach these decisions, and it may not always be. I mean, we've been very focused on arbitration, and the majority of our disputes will be ideally resolved long before you get to that formal process. And partly it's knowing that everything will be, everything has to be shared at that point. All those emails that you've written will be shared. That will sometimes propel the parties to come to a settlement. And it's precisely the issue that you've identified, Tim, which is that these projects are complex. And I do think in most cases it's actually the parties at the table that are the best equipped to resolve the issue. So, I mean, at the last, in the final instance, you do have these more formal mechanisms, and then you have to be concerned about having the right arbitrator there who has the right knowledge and who is able, and making those, advocating on behalf of your client. But ideally, I mean, the parties really best equipped to deal with this are the ones who are on these projects, understand the issues, and ideally, in an ideal situation, you come to a settlement before you go through a lengthy arbitration or litigation.
And so one of the challenges, I think. So, on one level, you've got an IO, which is, a procurement agency and has there's a degree to which you're going to be protecting the model and making sure it works, and which may be less true if it's a one-off institution, like a single hospital. It may be, as we joked about occasionally, deduction hunting, but not that they'd ever do that, of course. But you've got different dynamics at play between where you've got an institutional history to bring to that particular dispute and one where it's one-off. So how does that? How do you as an agency work that? But have you seen that, for example, Patrick, in terms of how the other side comes to the table around an issue?
Well, and it most certainly is shaping how we come to the table as well. Like, if you kind of engage in what a lot of us try to do, manage a relationship, do some horse trading, try to get through some contentious issues, and maybe not strict adherence to the contract, with these being 30-year assets that you own, the turnover of people and the attrition that occurs can create, and we found, a sense of improper balance on the value from what somebody now views as your previous agreement to where you're at now. And I personally, at least I can speak for myself, I'm finding more and more that adherence strictly to the contract usually plays out the best in the long run, and transparent adherence to the contract, being very clear of why you're taking your positions, and less worrying about friction and relationships and just worrying about being honest. And I know that sounds a little goofy, but ultimately, the perceived value in these relationships, when there's also procuring agencies overseeing them, can also change, our counterparty's behavior based off precedents that are being set from other assets that we're not engaged in. And on the flip side, us as investors that have a large portfolio, we can worry about a small decision here that might have a marginal effect to something that, if that carries forward to another asset, could be very detrimental to our investors.
Agnes?
Yeah, I think I mentioned this before, for us, there's an important distinction between routine claims and disputes. So there are certain aspects of the contract, such as deductions, fairly applied. That is actually the mechanism under the contract to incentivize proper good behavior. In the same way that there's a risk allocation when it comes to things like utilities, like contamination, where we as the contracting authority should not, if it's clear that that is our risk, and it's under the delay and compensation regime, then we should pay those without having to prolong that into a dispute. So I think seeing that as not taking those issues personally, and seeing that that's the mechanism of the contract, there will be certain payments made either way, and then focusing really in on those and spending our time and energy more on the actual disputes. So where there is a disagreement and where we do need to spend our time and energy because it will affect the relationship. I think too often the former items, the items that I consider more in the claims group, start to affect the relationship when they really shouldn't, because that is, there is, and I know there's sometimes it's criticized adherence to the contract, but that is, unless there's an ambiguity about the contract, that's obviously a different situation. But that is the mechanism in which, in fact, it often reduces the dispute. So having these types of deductions ideally are supposed to be a clear, this is what happens, and then there's no argument. If you didn't have that mechanism, then you'd be arguing about what the repercussion is. Well, what are my remedies? Can I go sue the party in court because I didn't get this? So that they're really designed to actually minimize disputes as opposed to, ideally, as opposed to increase the number of disputes.
I would also point out, one thing that is helpful is having a good counsel that almost provides a bit of a devil's advocacy approach to the positions you're taking. If your counsel is always an advocate for your position, you can find yourself getting far down the line in disputes that, in hindsight, based on decisions, based on maybe other precedences that have been set, you realize was unfortunately not the right approach, and maybe had they looked a little more negatively on your claim to start with, kind of went through all the steps, you might have ended up in a better approach. And we've most certainly had success with that lately, is just having somebody that really questions your likelihood of success through the process well before you get essentially 3/4 down the line, where the marginal cost to kind of get over the hump there is small.
So I like the difference between claim and dispute as a sort of a framing device. So my question then is so we put aside claim, in other words, the notion being, yes, that was a supervening event and there's a mechanic for it, or a deduction and there's a mechanic for it, subject to ambiguity. But so do we have a sense of what the disputes, not the claims, what the disputes are about? Is there enough of a fact base out there so we know they're of a certain kind, and then is there something we can then either do to the documents, or we as an industry, or do we just not have enough information to know how the disputes, as opposed to claims, are being, how they're arising and in what areas?
Yeah, I mean, as I mentioned before, we do have internal committees and continuous improvement mechanisms to identify when those issues arise, what they are, and how they originated. So I'll just give a very practical example that we've seen. And I mean, some of this is you learn lessons learned from past projects. But on our DBFM projects, there's sometimes a tendency to want to, on all sides, to reach substantial completion as early as possible. And sometimes the facility is not yet in proper operating or functional form. And if that process just plays out, what we've seen is that then that gives rise to a whole number of disputes during operations. So that's something then that we took back and tried to address through preventing that early substantial completion, or making sure that you have some sort of, there are valid reasons for reaching substantial completion early and starting the operational period early, is having some sort of an agreement, because you know that there will be these issues that arise, construction issues that affect the operational side. So that's one area we've certainly seen. We go through all these issues and when we try to rectify them on the front end.
Yeah. I mean, obviously different on the down the chain point. Those can arise for all kinds of creative reasons. There's another question here I thought is an interesting one, which is whether there should be different dispute resolution procedures for the construction phase or the operating phase, or does that same kind of tiered thing work in both, and it's just how complicated or simple or how much paper or not? So have you got any experience in it, and is there any reason why you'd change your dispute resolution procedure for construction versus operations?
The only thing I can think of out of the top of my head is the periods of time that an operating dispute must follow in the contract, should be probably lengthened a bit while parties kind of develop their positions. I know, it is beneficial to wrap up the D&C phase claims, whether they be arbitrations, et cetera, in an expedited manner, but in some cases, having a longer period of time to really evaluate an issue and put forward a discussion would be beneficial while parties work through what is the true impact of this O&M item. At least in my experience, that's what we've seen.
No. So we only got a couple of minutes left, so I'm going to do sort of a bit shotgun question. So I want to ask, actually, because I have you here, about tolling agreements.
Yeah.
And that issue of trying to protect, because there is some ambiguity in the documents about when the limitation period runs because of the dispute resolution process, and the question is, can you enter into, will public authorities agree to tolling agreements? How do we make sure that we're not fighting about dumb issues as opposed to getting around to resolving real differences?
Yeah, and maybe just for the benefit of everyone, just to explain, because
Yes.
4 years ago, I had no idea what a tolling agreement was. So, I mean, there's a limitations period under the Limitations Act of when a claim arises and how much time you have before you can bring that, bring forward a proceeding. And so that will sometimes then propel, because it's unclear if a claim, let's say a delay claim, has arisen at a certain point, whether or not that limitation period has expired for that claim. So we have agreed to those tolling agreements before, and some of that, and that's actually a great example of something we're considering making more clear in the documents, because the situations where we have agreed to it have typically been because we acknowledge that there might be ambiguity in the document about when, for example, for a delay claim, that delay claim has arisen. Has it arisen at the point in time where you thought you started, where the delay happened, or is it at the end at substantial completion when you know that a delay has actually happened? So in those incidences, we have agreed to tolling agreements, or there are other and that's something we're looking at fixing, because that shouldn't be the main reason for a tolling agreement. But there are other situations where tolling agreements can be advantageous, and sometimes where the parties are actually coming close to a resolution, and you're negotiating and you're coming close to some settlement, then you don't want if the tolling period is starting to expire, then what you're just forcing one party to do is, start a claim, start an action. And if you're actually resolving that together, then it can detract from that entire process of resolving the claim, the dispute.
Okay, so this is very quick. We're going to ask one more question from the crowd. This is whether they're binding versus non-binding arbitration. Do you think there is any worth in a non-binding arbitration? Basically, yes or no answer, starting with no.
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 Agnes?
No. I was just like all around.
Fair to say yes.
So there you go. So that is all the time we have. So I want you to, if you would, join with me in thanking the panel. Appreciate your insight and candor. Thank you very much.